Hello everyone, welcome back to my ACCA Law Revision series. In our previous lecture, we discussed about international organizations and courts operations. In today's lecture, we will be discussing about arbitration. Now, what do you mean by arbitration? In simple words, if I tell you the meaning of arbitration is basically nothing but settling your disputes outside of court. In an illegal way? No, that is not the word that I used. I said that you are settling your disputes outside the court with the help of a third person in arbitration arrangement, which is another legal way to resolve disputes. Now, how does it work? What does it exactly means? And what was the need of arbitration, that we will understand once we go further. Introduction to arbitration. It is a form of an alternative dispute resolution, ADR, and alternative dispute resolution, an alternative to courts, where parties choose to settle their disputes outside the court system by referring the matter to independent third party known as arbitrator or arbitration committee, meaning these parties mutually agree to resolve their dispute outside the court and to go and talk about their disputes, to resolve their disputes to third person. Basically, they go to third person to resolve the dispute. By agreeing to arbitration, parties can resolve conflicts impartially, efficiently, and cooperatively, aiming for mutual acceptance solution without the expense and delays of traditional litigation. In traditional litigation, we have seen that firstly, it is very expensive, and again, there are always delays. So if you want to avoid that, you and in fact both parties mutually can discuss and go to arbitrator or arbitration committee for resolving their disputes. Now, ma'am, how does this work? Firstly, if both of the parties want that if any dispute is there or if any dispute might arise in future, they firstly should have an arbitration agreement. If you want to refer your dispute to arbitration, you must have an arbitration agreement. It is a written agreement, specifically said that it has to be a written agreement where parties come together and they mutually agree that if any dispute arise, they will resolve or such specific disputes through arbitration, be it current or future disputes. Meaning, let's say for example, I and one of my student are under dispute. Let's say I bought some goods from that student and I was supposed to pay money, but before entering into the contract, we both made an agreement, a written agreement, that if at any point of time any dispute arise, let's say I don't pay him or the student don't give me exact goods, exact product, or exact quality, we will make sure that we are taking this dispute to arbitration proceedings, to an arbitrator, and we will not be going to court. So it can be a future dispute also, that if in case dispute might arise, we will go to arbitration. Or it can be current also, that let's say there was no such clause written, but later on any dispute arise, we come to a mutual agreement, we make an arbitration agreement, and we say that this dispute, this particular dispute, we will be dealing in arbitration arrangement. It can appear as a clause or as a standalone arbitration agreement, meaning let's say if you have entered into a contract, these are a few terms and conditions of the contract. Any one clause can be of arbitration, or you can also prepare an entirely separate agreement, meaning you both the parties mutually decide whether to put it into a clause of the current ongoing contract or to create altogether another separate agreement. Now, Under article, I hope it's clear. Yeah. Under article 1 subsection 3, arbitration is international. So we discussed that this is how arbitration works, but again it can be domestic and international as well. What are we studying? We are studying international arbitration. So in what cases can you say that this particular arbitration is an international arbitration? So the first point says that a substantial part of contractual obligation is performed in another country, meaning, let's say at any point of time, let me give you an example quickly, that Mr. X and Mr. Y, they both are from India, all right, and they both enter into a contract that a bridge will be made in, let's say, Nepal. In such case, the substantial part of contractual obligation, meaning the entire contract has a main obligation, the substantial, meaning a very important part of this entire contract and obligation is building the bridge which is situated outside India, which is situated internationally. Basically, the substantial part of contractual obligation means the bridge that we are discussing about is performed in another country. In that case, it will be called as international arbitration, because the bridge or the substantial obligation of the contract is situated outside the country or is performed in some other countries. Parties have place of business in different countries at the time of agreement, which is obvious. Let's say Mr. X resides in India and Mr. Y resides in UK. In such scenario, both the parties are from different countries, belong to or are resident of different countries. In such case, this become an international arbitration agreement, or parties expressly agree the subject matter involves multiple countries. So again, let's say if both the parties are from the same country, but they mutually agree that if in case at any point of time any dispute arise, we will refer to an international arbitrator, or this contract is a international arbitration agreement. If at any point of time these three clauses are there, are applicable, then and only then it is an international arbitration agreement or an international arbitration clause exists. Now, under Article 3, any written communication will be considered delivered if, meaning, let's say the agreement is made. As I said, let's say Mr. X reside in India and Mr. Y reside in UK. In this scenario, the agreement, written agreement made, is both the parties are separated, like are sitting in a long distance. They both are not sitting face to face and a printout is coming and both the parties are signing. That is not happening. So in such case, the written communication will be considered as delivered, meaning, let's say Mr. Y says that we should be getting into arbitration agreement and Mr. X agrees. They have to write a arbitration agreement in a written form. Let's say Mr. X gets it in a written form and signs over it and sends it over to Mr. Y. When will be this termed as delivered? If it is delivered to the addressee personally, meaning he's personally going there and delivering, which is almost not possible until and unless you have a branch in that country and you are mailing it to the branch and you're telling the branch manager that please go and deliver it to the person personally, or deliver at the place of business, habitual residence, or mailing address, meaning the place of business is where your actual main business is residing, where you have the place of business. So let's say, ma'am, I have a lot of branches all over the world, in that case, you can say your head office is your place of business. Or if the place of business is not very clear, then wherever you reside or your mailing address, if none can be determined, deliver to the last known place of business, residential or mailing address. If the above cannot be determined, that Mr. X is not able to find these details, then the previous details that Mr. X have. Now, communication is deemed received on the day it is delivered. What do you mean by this? Let's say Mr. X sent it the agreement on 14th. Is it- All right. On 14th of September. All right. And so he mailed it on 14th of September, let's say draft, let's say post, through post or something like that. On 18th of September, he got to know that it is in transit. 20th of September, it was delivered at the place of business of Mr. Y. And 22nd September, Mr. Y read it and accepted it. In such scenario, the clause says that communication is deemed received the day it is delivered, meaning once it is delivered on the place of business, irrespective whether the party has gone through it or not, it will be termed as deemed delivered. Relevant court or authority is where the arbitration is seated. Now, ma'am, you said that it is a third person handling the entire dispute. Why is court required? Why is court word coming in this scenario? We will understand that briefly when we go through forward in our lecture. But basically, if I have to give you a brief, that any point of time anything goes wrong during the arbitration process, the court that the parties will refer to will be which court. Because let's say, ma'am, arbitration has been opted for, and this person is from India, that person is from UK, and they have discussed that the arbitration proceeding will happen in UK, but they did not discuss that if at any point of time any court proceedings is supposed to be happening, which place that proceeding will happen. In such scenario, where the arbitration proceeding is supposed to be happening at that place's court, meaning that country's court will prevail. If you have to go to the court, you can go to that country's court. In our example, it will be UK court. The relevant court or authority is one rendered in the country of arbitration where the arbitration proceedings is taking place. Now, arbitration tribunal. Now, what do you mean by this? Meaning the entire proceeding where the proceeding goes on, that is an arbitrational tribunal, and a list, a step by step details is given that how you are supposed to follow an arbitration process. The number and procedure of selecting the members of tribunal is decided by the parties, meaning let's say there is Mr. X and there is Mr. Y. So the members and the number of members that will be sitting in this entire proceeding is decided by the parties. So let's say both the parties decide mutually that 5 members will be sitting in the arbitration process, and both of these will select these 5 members mutually so that nothing goes wrong or no biased decision is taken. But if parties are unable to appoint arbitrators, there will be minimum 3 arbitrators. Ma'am, why in case of court there used to be only one judge? Why there are so many number of arbitrators here? That is because this is an outside settlement of court, and their judges are supposed to be termed as a highly extremely qualified judges. Here, let's say if there is only one arbitrator, one person might say that that particular arbitrator is not correct as per me, and I want a person who understand my country's rules and regulations also, and vice versa. In such case, liberty is given that you can select whatsoever number you want to select, that these number of people will sit together and they will be discussing um things which are not going right, or the dispute that has happened. So let's say two people from my side and two people from his side will come together, sit in the entire proceedings. However, if they are not able to come to a final conclusion, if both the parties are not able to do that, in such case there will be a minimum of three arbitrators. There is nationality of these arbitrators is not a barrier to an appointment. These arbitrators can hold any nationality. If no agreement of appointment process, let's say, now as I said, both of the parties selected four arbitrators, two each party will decide, but they, let's say they were not able to select these four, then in such case three arbitrators were selected. Again, three, both the parties can decide which three people will be sitting. Again, if they are not able to decide or finalize the total three number of arbitrators, or the total three arbitrators, in that case one arbitrator each party will be appointing, and then these two arbitrators will come together and select the third arbitrator. That is what is written here, that if no agreement on appointment process, each party appoints one arbitrator and then those two arbitrators select the third arbitrator. Now, if a party or the two arbitrators fail to make necessary appointments within 30 days of being requested to do so by the other party, the relevant court or authority will make necessary appointments. As I said that, ma'am, why is court relevant here? Why did we discuss the point of that court? It is relevant because let's say both the parties appointed one arbitrator. Now these two arbitrators are supposed to appoint the last arbitrator. Let's say these two arbitrators are also not able to appoint the last arbitrator. In such case, within 30 days of them being informed that you are supposed to appoint the arbitrators, let's say within 30 days both the parties were informed today that you are supposed to appoint the arbitrators. Today starts for within next 30 days. If these two parties are not able to appoint arbitrators and decide a number of arbitrators, so on and so forth, in such case relevant court, meaning the court where these arbitration proceedings are going on, will make the necessary appointments. Court will come into picture and appoint the arbitrators. Now, let's say challenging an appointment, meaning let's say court has appointed these three arbitrators, or these two arbitrators have appointed one arbitrator, or both the parties have appointed three arbitrators. At any point of time, any party feels that this arbitrator, this person who is appointed as arbitrator, is not right. In such case, parties can challenge the appointment. What happens if parties challenge the appointment? Challenge meaning they can say that we are not okay with this particular person acting as an arbitrator. In such case, firstly, tribal continues to function during the challenge. Let's say you've appealed, you've made a request that this is not okay. They will take that time to respond. Until that time, things, however it is working, will continue working. Appointment, at any point of time you can challenge on the grounds that appointment is partial, not independent or unqualified. Let's say Mr. X and Mr. Y. Mr. X has appointed someone and Mr. Y has appointed someone, and these two arbitrators have appointed third person, but Mr. X feels that this third person is not qualified enough to become an arbitrator. He can challenge it. Or Mr. Y feels that this person, this third arbitrator, will be favoring Mr. X more. In that case, also Mr. Y can challenge the appointment. Party can seek removal if they appointed, even if they have appointed their own arbitrator. So let's say Mr. X had appointed one, Mr. Y had appointed one arbitrator. Both the parties have appointed one arbitrator. Going forward during proceedings or so, Mr. X feels that the arbitrator that he has appointed is actually being biased. Probably he might have gotten money from some party and he's not. Basically, he is being biased. He is not giving correct judgments, or he is not listening to Mr. Y's pleads or proofs. He is not even seeing to Mr. Y's proof. Sorry, Mr. X proofs. So, in that case, Mr. X can say that I don't want this particular arbitrator. I want to challenge the appointment. Meaning, even if the person he himself has appointed an arbitrator, that person he himself can challenge the appointment, even though I have appointed this particular person. Challenge to tribunal within 15 days of knowing appointment. Meaning, let's say appointment happened on day 1. Within 15 days, you can challenge the appointment. If rejected, if your challenge is rejected by the tribunal, you can go to court within 30 days of being rejected. Meaning, let's say day 1, you have challenged, day 1, the appointment was made. Day 10, you have challenged. Okay. In this scenario, day 15, the challenge was rejected. So starting from day 15, within 30 days you can go to the court, and whatever court says, court's decision will be final and binding. Now, if an arbitrator resigns, then a new arbitrator will be appointed using the same process as earlier. Whatever process we have followed or we have discussed up till now, the entire same process will be followed if at any point of time any arbitrator resigns. I hope this point, like these are clear. It might be a little heavy as we are doing, like if you are a person who is studying this for the first time, it might feel a little heavy for you because we are into revision series. If you still feel, or at any point of time any students have any doubt, you can ask that in the comment section, and I'll make sure that your doubt is solved. You will definitely get a revert within a day or so. But I hope you understood this. Now, how does proceedings takes place? So we, up till now we discussed how committees form, how tribunal works, who are the people who are these third party people who are sitting there and listening to our uh let's say listening to whatever we are saying and solving our disputes. Now, how does this proceeding works? Now let's say we have already appointed the arbitrators. Now what they are supposed to do and how it will they will help us in coming to a conclusion. So firstly, please on jurisdiction, meaning let's say improper jurisdiction or excess of jurisdiction. Meaning, at any point of time, the proceeding is going on, and any point of time, any party feels, the first point says improper jurisdiction, meaning at any point of time, let's say Mr. X and Mr. Y, at any point of time that the party feel that this is an improper proceedings going on, or improper jurisdiction is going on, they can plea for it. Meaning, they can raise an objection that tribunal lacks authority. What do you mean by that? Let's say if I give you an example, that Mr. X and Mr. Y, they both went into arbitration proceedings. However, they did not had any written arbitration agreement. So, if let's say Mr. X was not okay with going into arbitration proceeding, and also they did not had an arbitration agreement, in such case Mr. X can raise his voice, can raise an objection of improper jurisdiction, but this objection must be raised before filing the defense statement. Meaning, Mr. Y has filed the statement that this is what has happened with me. All the arbitrators have been selected, have been appointed, and Mr. Y is saying that this is my defense statement. Up till that time, X is given time. But if Mr. X also files his defense statement, in that case, now Mr. X can no further raise an objection. But if Mr. X is not okay with it, Mr. X can raise an objection at any point of time before filing the defense statement. Or excess of jurisdiction. Let's say Mr. X and Mr. Y entered into a arbitration agreement wherein they discussed that at any point of time, anything related to quality of goods is an issue. We will go and resolve this dispute under arbitration. Okay, so this is written in the arbitration agreement. But while doing the arbitration proceedings, the tribunal, the people, or the in the proceedings, payment issues are also being discussed. So, in that case, tribunal is acting beyond its mandate, meaning the arbitration agreement said that only disputes that are related to the quality of goods can be discussed. If there is anything, meaning if there is anything apart from the quality of goods, meaning for, let's say, payment issues or delivery timing issues, so on and so forth, all of those cannot be referred in arbitration. However, if they mutually decide and make a separate agreement, then they can, otherwise they cannot. And during the proceeding, the arbitrators were discussing about quality, but they also start discussing about payment. In such case, either of the parties can raise an objection, and that objection must be raised immediately when that incident occurs, meaning immediately. Let's say the arbitrator just said some statement about the payment and Mr. X has a problem with it, then Mr. X has to immediately raise an objection saying that this was not covered under our arbitration clause. You cannot, the proceedings is completed, or let's say the payment issue was discussed in day 2, you cannot come to day 10 or after everything has been completed and say that this was wrong. You're supposed to say that immediately at that point of time. Tribunal procedural autonomy, meaning uh, how does procedures go on? It continues proceeding even if at any point of time any party disagrees with the procedure. No delays allowed. Tribunal controls the process. If you have any problem that the proceeding is not happening properly or something off is going on, even though, so we discussed this up also, if any objection is raised or challenge is there, the proceedings will still be continued the way it is working. But ma'am, let's say the proceedings is continuing and they came to a conclusion and the court has not replied. In that case, we will discuss what can happen, how you can challenge the final conclusion. Language of arbitration. In what language will this arbitration take place? So let's say two different people are from two different countries. One person is very fluent in English and he does not know any other language apart from English, and second person knows all the languages. In that case, both parties can come together and they can agree on one single language which can be used. If party don't agree, then in that case tribunal selects the language. Document exchange. All the documents that you're showing as a proof must be submitted by the parties and must be shared with all the parties. So let's say I'm Mr. X and I'm submitting a few documents, then these documents will also be shared with Mr. Y and all the parties. There is full transparency. All documents relied on by tribunal must also be communicated, meaning it should also be communicated to the tribunal that these are the documents that has been submitted. And if tribunal is giving any document or saying anything about it, all the parties should know. Basically, there should be a full transference. No appearance or non-appearance or non-submission at any point of time, any party does not appear for the proceeding, tribunal will still continue the proceeding. In court, that is, I think, not the case. But here, if any party does not appear, tribunal will continue the proceeding. And if parties don't provide enough evidence, tribunal can make the final decision based on available material. So let's say Mr. Y has given a lot many documents and Mr. X is still struggling, and and even after repetitively being asked, Mr. X has given only one document, then tribunal will not wait for Mr. X to actually take out time from his personal life and give the all the documents to tribunal. Tribunal will take a decision on whatsoever documents tribunal has. Failure to file a statement of claim, meaning claimant fails to file a claim without a valid reason, tribunal terminate the proceeding. Let's say Mr. X and Mr. Y has started the proceedings, but they are not able to give any document. They are not coming for like both the parties are not there during the proceedings. They are not coming into the proceedings. They are not giving any documentation. They are not giving any valid reason for their dispute. In that case, tribunal will stop the proceeding and say that we are not going to take this any further because apparently there is no dispute. Now let's discuss about arbitration award. Now, what do you mean by arbitration award? Basically, it is the conclusion of the entire dispute. An arbitration award is the final and mm, binding decision, meaning whatever the dispute was going on, whatever on the conclusion that arbitrators came, that conclusion is called as arbitration award, and that arbitration award is final and binding, given by the tribunal on the dispute submitted to arbitration. In simple words, judgment of the arbitrator, just like a court judgment, and which decides the rights and liabilities of the parties. Whatever, let's say in the court, the judges give a judgment. In arbitration, it is called as arbitration award. Now, how does this works? How does arbitration award works? Meaning, let's discuss features of arbitration award. I hope it's clear enough. So let's discuss features of arbitration award. The first one is it is a final decision of the tribunal, as we just read that it is final and binding. How do they come on this final decision? By taking a majority of vote, meaning out of three, two people are saying yes, Mr. X is liable, and only one person is saying no, Mr. X is not liable. In that case, there is a majority, then X will be liable, so on and so forth. Settlement during the proceedings. Parties settle the proceedings at the end, meaning settlements happen at the end, and tribunal may issue settlement as a reward. Basically, the conclusion, whatever is there, is a settlement reward that happens at the end. Now, form and signature. Whatever award is written, arbitration award, that award should be in a written form and it should be signed by all the arbitrators. So let's say in award, it should be it is explicitly written that two arbitrators agree, there is a majority, and Mr. X is liable, and all three arbitrators are supposed to sign in this written award which is there. Court intervention on the grounds. When will court intervene? We just discussed the very first scenario where anything is beyond jurisdiction. Let's say in award it is written, let's say in our example there was about quality, but in award it is written about quality as well as payment. In such case, such award is beyond jurisdiction and court can intervene. Or improper notice to the party. There was no notice given to the parties. In that case, parties can go to court and say that we had no notice of the appointment of arbitrator or so on and so forth. In that case also, court can intervene. invalid arbitration agreement. The agreement that was made was an invalid agreement, was not a valid agreement. In that case also court will intervene. And against a public policy, let's say there was a arbitration agreement and arbitration award has been given, but that arbitration award is against a public policy, that arbitration award is against a public policy and it might cause harm to public at large. In that case also court will intervene. What do you mean by an invalid agreement? Agreement we will discuss in detail, what do you mean by agreement, so on and so forth. But an invalid agreement means it has no um what do you say, it has no back end of court. It is not valid in court, it will not work in court, it is a wrong agreement, it is something which is invalid. I like, it's basically it is not enforceable by law, to be precise, if I use the legal words. Now, ma'am, the award is granted, but at any point of time, any party feels that we are not okay with the award, we don't agree with the award. In that case, a correction can be requested within 30 days. Let's say if in the award it says that uh, Mr. X is supposed to pay on 10K, however, Mr. X feels that he should be paying only 9K. So he can ask for correction uh, within 30 days of this arbitration award being announced, or an additional award is requested within 30 days. So let's say the proceeding happened, and in proceeding two things were discussed, something about quality and something about delivery also. The award is granted, however it covers only the quality part, the delivery part is not covered. In that case, the delivery part can be asked as an additional reward. They can go to the tribunal and say that this part is still pending, can you come to a final conclusion and give us an arbitration award on the delivery part as well. In that case, that award can be also requested within 30 days. If additional award is proper, additional award will be granted within 60 days if it is justified. So the ongoing award, if you want any correction in the award, you can make ask them for the correction within 30 days. If you want an additional award, again you can ask for an additional award within 30 days. If the award is justified, if that additional award point is justified, you will be given that additional award within 60 days. These are some timelines that you should remember. The starting date of proceeding is the date at which the request to refer the dispute to the arbitration is received by the respondent. Meaning, we discuss so many days, within 30 days, within 60 days, so on and so forth. Then, what is the starting date of the arbitration? The starting date of the arbitration is when the request is received for the dispute by the respondent, meaning the person who is at the side, he receives a request or accepts the request. The date at which request to refer the dispute to arbitration is received by the respondent, that this is some let's say this is some dispute. I think we have, let's say, Mr. X and Mr. Y. Mr. X says that we have this dispute and I'm requesting you, let's go to the arbitration proceeding. The day the Mr. Y receives the request, from that day you can say that the proceedings have started. A few advantages of arbitration over court: of course it has speed, it is much faster compared to court litigation, and fewer procedural lawyers, and it is basically a flexible uh, process. It has lower cost, faster proceeding, plus less formalities, lower overall cost. It has privacy, usually in case if you're going to court, all your disputes are held in court, and any person, let's say if I'm a person, I can go and sit in court and listen to the case that is happening. There are no restrictions, but that also means there is no privacy. Here there is privacy, there is confidential, only the arbitrators and you, the all the topic and all the dispute stays between only these people. It is informal and more flexible, less rigid, easy discussion. There are not so many courtroom rules and regulations that you're supposed to follow. Expertise, whatever arbitrators that you are selecting, they might be expertise. They have expertise in that particular field or in that particular kind of disputes. Let's say if I am an arbitrator and I always have been resolving disputes that are related to buy and sell of goods and not services. So if any party or any person who has dispute which is related to goods or buying and selling of goods and they are appointing me, I have solved so many cases related to that. So I am a expert person in that, and that is the expertise that you get. And neutrality, meaning it can be held in a neutral country where concerns can be discussed in a better way. Let's say if I'm from India and the other party is from UK, we both can also mutually decide that in some X country our dispute will be held and our dispute will be resolved so that everything is neutral. However, a few advantages of court over arbitration: judicial expertise, meaning strong legal reasoning is there. The person, the judge who is sitting there, has immense knowledge of what is right and what is wrong legally, and they are legally trained. So they are expert judicial wise. Predictability, meaning decision flows from established laws and precedents. Let's say if your case is there, such case if has already been there, then that decisions will flow because such case is already there. Then in that case your time consumed will also be less, and it will be more predictable conclusion, so you get a better clear outcomes that what could have been the outcome or what might be the judgment. Appeal structure, this is one of the most important cases here, that in arbitration that is final and binding. Okay, you can go to court only in few circumstances, but here if any party is not okay with the final judgment, in that case you can go and multiple levels and you can appeal. Arbitration, there are very limited grounds to challenge, as we discussed. When can court intervention, there are only what's, let's say, only four grounds where you can challenge or court can intervene, but here there is no such restriction. If any party disagree, they can go and appeal. All right, guys, with that, chapter number 1 is done. We have covered part A and part B, every single thing, every small concept and basics that is required for you to appear your exam. Now, what I want from you is to revise everything once again, because in my next lecture, I'm not going to teach, I'm going to test. So basically, in my next lecture, we will be solving MCQ of this entire chapter number 1. If this has helped you in any way, do like and share it with your friends and subscribe for such upcoming revision videos, because I will be covering the entire law syllabus. See you in the next lecture.